businesses are extensively shifting online. Whether a business is completely or partly digital, a chunk of its customers, outreach, and marketing is now online. As the digital world becomes the playing field for businesses, the regulation of the space becomes even more important. While existing laws apply equally to the online and offline space, the special transborder nature of the digital medium and the unique opportunity presents special challenges and demands unique solutions, taking up the issue of anti-competitive practices by big tech companies. Now the question is, why have a new law at all? There are two main reasons. The world has undergone rampant digitization in the past few decades, leading to a number of powerful business models emerging across sectors. The business models and digital markets are being led by some critical players, collectively referred to as big tech. The ecosystems created and innovated by these players are at the heart of the digital revolution. India is not untouched by this global revolution. In fact, with rampant digitization, cheap access to telecom networks, India is leading the growth of e-commerce and artificial intelligence, leading to benefits to a legion of consumers. From buying an iPhone to groceries or even real estate, businesses are extensively shifting online. As businesses shift online, so did competition. Whether a business is completely or partly digital, a chunk of its customers, outreach, and marketing is now online. As the digital world becomes the playing field for businesses, the regulation of the space becomes even more important. While the digital ecosystems have been created and innovated by big techs and they have immense benefits, there are also intense debates over the interaction of these ecosystems with its users, both end users and business users. The issues pertaining to anti-competitive practices, protecting consumer data, ensuring quality of products sold online, and much more. While existing laws apply equally to the online and offline space, the special transborder nature of the digital medium and the unique opportunity presents special challenges and demands unique solutions. The debate and scrutiny were manifested in the 53rd Parliamentary Standing Committee on Finance, taking up the issue of anti-competitive practices by big tech companies. In its December 2022 report, the committee noted that there are 10 anti-competitive practices commonly engaged by big techs and suggested that India develops an ex-ante law to address those. Following this, in February 2023, the Ministry of Corporate Affairs set up the Committee on Digital Competition Law to examine the need for an ex-ante framework. The final report of the committee was released on 12th of March 2024, recommending indeed an ex-ante or preventive framework. This framework has been envisaged in the form of a Digital Competitive Act or the DCA. The draft form of the law or the Digital Competition Bill or the DCB has also been recommended by the committee. With this proposal, India seeks to join the increasing cohort of countries which are enacting similar laws. Now the question is, why is it an ex-ante law? With intense debate around ex-ante, let's first understand what an ex-ante law is all about. Typically, regulatory laws are designed to address wrongs or illegalities committed by the regulated entities. The law would define what is wrong and even lay down some detailed guidelines around it. If a player in the market is alleged to have contravened it, the regulator would examine it. The examination involves giving the regulated entity an opportunity to demonstrate why its conduct is not wrong. Based on this assessment, the regulator would then arrive at a finding and then might decide to impose penalties and ask the regulated entities to change its behavior. This is the model that the current competition law in India, that is the Competition Act of 2002, operates in. This model is also called the ex post model, as regulatory scrutiny is after the regulated entity has done or committed a wrongdoing. Now, an ex-ante law reverses this approach. Under an ex-ante law, a prescriptive framework is laid down which is often based on an assumption of certain specified conduct being incorrect. The regulated entity is required to comply with the letter of the law, and if it fails to do so, it is presumed to have acted in contravention of the law. The opportunity to justify itself are also far more limited. The difference with the ex post law is in that sense subtle but critical. Equally, no law is purely ex ante or self-executing. Even an ex ante framework will require assessment of contravention only once the contravention has been committed. Let us now examine the Digital Competition Bill and what it says. Under the DCB, the Competition Commission of India or the CCI remains the enforcement agency. So, CCI will be enforcing the Competition Act and the Digital Competition Bill and also serving as an anti-profiteering authority under the GST. The law is based on two fundamental concepts: core digital services or CDS and systematically significant digital enterprise or SSDE. As the word indicates, core digital services is about businesses which are solely online. It includes services like the online search engines, online social networking services, video sharing platform services, etc. The CCI is authorized to designate entities that meet certain criteria showing that they have significant presence in one or more CDS as systematically significant digital enterprises or SSDEs. Further, the CCI may also designate certain entities that are associated with the SSDEs as associate digital enterprises or ADEs. However, the designation is based on self-assessment. Entities must notify the CCI within 90 days of meeting the financial or user-based thresholds that they are now an SSDE. Based on this notification, the CCI will issue a formal designation. So those are the two broad classifications that exist. Finally, the core of the Digital Competition Bill is the designation of certain conduct as prohibited. These designations are much more prospective and specific compared to the general designations found under the ex post law like the Competition Act. So if you are an online business, you would be covered under this law and shall be categorized or designated to be a regulated entity under this new regime. Let us now examine what are the activities prohibited under the new digital competition law and what happens if you don't comply. 1. Online businesses must compete in a fair, non-discriminatory and transparent manner with end users and business users. 2. They must not engage in self-preferencing, that is, favoring its own or affiliated products or services or lines of businesses. 3. They should comply with certain obligations on data usage. 4. They should not engage in tying or bundling any products or services along with the CDS. 5. They should not restrict or impede the ability of end users and business users to use third-party applications or third-party apps. 6. They must allow for end users and business users to change default settings. And finally, 7. They shall not restrict business users from directly or indirectly communicating with or promoting offers to their end users or directing their end users to their own or third-party services unless such restrictions are integral to the provision of the CDS itself. As I mentioned, the law can't purely be ex-ante and certainly can't be self-executing. Whilst the DCB lays down prospective requirements of what can't be done, there is an ex post element of what happens when an entity does not comply with the requirements of the DCB. The inquiry procedures in the DCB are similar to those in the Competition Act. The CCI can order the Director General, which is the investigative wing of the CCI, to investigate any breach of the obligations by an SSDE or an ADE. To do so, the CCI must first be satisfied that a prima facie case exists based either on its own motion or on a complaint filed by any person or by a statutory reference made by an institution. The CCI is required to give an opportunity of hearing to the SSDEs or the ADEs before arriving at a final decision. The CCI also has the powers to issue interim orders during the course of an inquiry in appropriate cases. Now, what are the reasons for the Digital Competition Bill to come into existence? Many of the listeners may be wondering, and rightly so, why DCA is being proposed. Now, the DCB is very similar to the Competition Act in terms of the processes and the procedures and even the prohibited activities. Those who are interested in competition law would recognize that the Competition Act bars conduct which is similar to what is barred by the proposed DCA. In fact, the CCI has decided cases and found entities to have acted in contravention of the Act. For instance, discrimination between users, favoring its own product, and restricting business users from directing end users to a third-party product. If so, then why have a new law at all? There are two main reasons guiding the new law: the sheer dynamic nature of the digital markets and the ability of online businesses to transcend borders. The common refrain across for having such law is the nature of the digital markets itself. Digital markets are driven by network effects with increasing returns to size, which means that businesses tend to have lower cost yet increasing their returns as they grow. It is argued that this leads to businesses attempting to scale quickly by all means necessary, resulting in a winner-takes-it-all market outcome where one or two players capture majority of the market. As a result, digital markets are quite dynamic and innovative in nature, with one or two market players emerging as leaders within a short span of time. The DCB has been heavily influenced by other jurisdictions such as EU's Digital Markets Act, UK's Digital Markets Competition and Consumer Act, and Germany's Act Against Restraints of Competition. Similar to India, these regulations identify that traditional tools are not adequate to address anti-competitive practices in digital markets and instead recommend obligations and prohibitions for certain designated firms that possess some form of market power, not necessarily dominance. Such firms, identified based on qualitative and quantitative factors, have been subject to ex-ante intervention. Now, critics of the law have their say. Before we end, my two bits on whether the law is needed and, if enacted, what are the gaps in the current version of the DCB. The DCB has faced significant resistance from all quarters. Not just tech companies, but MSMEs and industry bodies have been vocal in their critique, and I think this is not without reason. DCB contains several aspects that are concerning not only for specific markets but also for the regulator itself. I will set out some of them. First is the designation of SSDEs. The designation of SSDEs has been at the center of many concerns with the DCB. The definition of an SSDE is broad enough to capture numerous entities that may not even have significant market power. This broad scope is coupled with a fear that the regulator will hamper the potential growth of many homegrown startups, which would ultimately have the effect of stifling innovation and impacting consumer welfare. Second, there is a major concern about the excessive compliance burden that the DCA will impose on companies. This increase in compliance burden can significantly impede innovation, leading companies to redirect costs to ensure compliance, as companies might have to shift the cost burden. Enactment of a new law raises questions about why the law is needed and what is the appropriate way to address the concern. In my view, the reason for enactment of a DCA are far from clear and compelling, and even if enacted, only time would tell the benefits that it can bring along.